There's a federal court decision from February of this year that every attorney using AI tools in their practice needs to read carefully, not because of what it held, but because of what it did not hold, and because a significant amount of the published commentary about it, and a lot of the scuttlebutt I heard at ABA Tech Show and I've seen on Reddit, is mischaracterizing the scope of the ruling in ways that could lead attorneys to draw precisely the wrong conclusions. That case is U.S. v. Heppner, decided in the Southern District of New York on February 10, 2026. If you have read any of the dozens of law firm alerts, bar journal articles, or legal tech newsletters that have covered it since then, there is a meaningful chance you walked away with an incorrect understanding of what the court actually decided and didn't decide. I want to be direct about this. I spotted this problem early, and I want to walk through it carefully with you because the practical stakes for your practice are real. The misread pushes in the direction of excessive caution about attorney AI use that the Heppner court specifically did not address, and the issues the court did definitively resolve about client AI use and the conditions under which privilege is lost are being underemphasized in ways that leave attorneys without the practical guidance they actually need. So let's look at what Heppner actually says, what it actually does not say, what the ethics guidance actually requires, and where the real traps are, including one that most of the Heppner commentary is not even discussing, which is the AI meeting note-taker problem. Welcome to Spellbinding IP. I'm Julie King, patent attorney, IP attorney, and lifelong horror and rock music enthusiast. Why am I talking about all of this? Well, I have a master's degree in computer science with coursework in artificial intelligence and natural language processing. I've been evaluating legal technologies since before most of the tools attorneys are currently panicking about existed, and I've been publishing on AI and IP law since December 2023. This is the companion episode to last week's business owner and creator-focused episode on AI and IP. If you're not an attorney, that episode is the better starting point for you, and the link is in the show notes. This one is largely for the attorneys, but it does have some information you may find interesting if you aren't a lawyer. So let's get into it. Let's look at the facts, the body in the room, and read the case carefully. The defendant and Heppner, facing federal criminal charges, used the free consumer version of Anthropic's Claude, not an enterprise tool, not a paid subscription, the free public-facing tier, to generate 31 documents analyzing his legal exposure. He then forwarded his documents to his attorneys. The government moved to compel production of those documents. The defendant argued they were protected by attorney-client privilege and alternatively as work product. The court rejected both arguments and ordered production. I think they got it right. Let's look at the three grounds. The court held that the AI-generated documents were not protected by attorney-client privilege on three independent grounds. Let me walk through each one carefully because the specificity of these grounds is exactly what much of the published commentary is glossing over. Ground one, Claude is not a lawyer. We all know that. The attorney-client privilege protects confidential communications between a client and their attorney made for the purpose of obtaining legal advice. Claude is just not an attorney. Therefore, communications with Claude are not communications with counsel. This ground is uncontroversial and uninteresting for our purposes, so it does foreclose an argument some have made that AI acting as a legal assistant could somehow be analogized to the attorney for privileged purposes when the client is using it. Ground two is there's no reasonable expectation of confidentiality. This is the most important ground for practitioners and the one most analysis is not being sufficiently precise about. The court held that the defendant had no reasonable expectation of confidentiality in his communications with the free consumer version of Claude because Anthropic's terms of service for the free consumer tier explicitly reserve the right to access and review conversations. The court relied on the specific terms covering that specific product tier, the free consumer Claude, not the paid subscription, not enterprise, the free tier. The court also cited a companion district court observation from INRI OpenAI that AI users do not have substantial privacy interests in their conversations with publicly accessible AI platforms that users voluntarily disclose to the platform and that the platform retains in the normal course of its business. Ground three is that the interaction with Claude in this case was not made for the purpose of obtaining legal advice and not under attorney direction. Even if we could somehow get past grounds 1 and 2, the documents would still not be privileged because they were not made at the direction of counsel and were not created for the purpose of facilitating legal advice. The defendant went to Claude on his own without being asked or directed to by his attorneys. The court was explicit that this matters. It noted that the law firm never asked the client to do the AI research he did. So the work product claim failed for a related reason. Work product requires that the material be prepared in anticipation of litigation under the direction of counsel. Again, the client acted independently, not at counsel's direction. Now here's where we get to the misread. The court's ruling on grounds 2 and 3 specifically tied to the facts of this case, a client using a free consumer AI product on their own initiative without attorney direction. The court did not hold and conspicuously did not address several questions that most published commentary is treating as though Heppner resolved them. Here's what Heppner did not decide: whether an attorney's own use of AI tools in preparing work product is protected. The client was not an attorney. The client was not performing legal work under counsel's direction. The court was not asked to and did not address attorney use. Whether AI tools with enterprise-level contractual confidentiality provisions would give rise to a reasonable expectation of confidentiality. The court's ground 2 analysis turned on the specific terms of the free consumer tier. An enterprise agreement with a data processing addendum and explicit confidentiality provisions presents a materially different factual picture, and this court left that question open. Whether the client use of AI at counsel's direction under the Kovel doctrine could be protected. The Kovel doctrine from U.S. v. Kovel from 1961, crazily enough, extends attorney-client privilege to third-party agents who assist the attorney in providing legal services when those agents are acting under the attorney's supervision and the communication is made for the purpose of obtaining legal advice. Now, the Heppner court explicitly noted that the law firm never asked the client to do the AI research, and that language is important. It signals that the outcome may have been different if the attorney had directed the client to use an AI tool as part of a specific legal task. The court left the Kovel question, in this case, open. The practical upshot is that Heppner is a client use case about a free consumer product. It is not a holding about attorney AI use. It is not a holding about paid enterprise tools, and it leaves open a pathway for Kovel-style analysis when clients use AI at counsel's direction. The attorneys publishing alerts saying Heppner means you can't use AI for privileged work at all are extrapolating from a consumer client use case to attorney use, which the court did not address. That is the misread. That said, Heppner does give us clear, actionable guidance on one thing. You need to counsel your clients about their AI use. If your clients are running their legal problems through consumer AI tools on their own initiative and then forwarding you the output, Heppner tells you those documents are producible. That is a real and significant practice management issue regardless of what product tier they're using. So if Heppner didn't answer the question of attorney AI use and privilege, where does that leave us? The answer is in genuinely unsettled territory with some useful analogies and guidance from the bar that does help us navigate. The email analogy is instructive. I remember this well because this is exactly when I became a licensed attorney. In the late 1990s and early 2000s, there was a real and serious debate in the bar about whether attorney-client communications conducted by email were privileged. The concern was that email passed through third-party servers, that ISPs had technical access to the content, and that this third-party transmission might constitute a disclosure that waived privilege. Legitimate concern. State bars issued ethics opinions, the ABA weighed in, and eventually the profession reached a working consensus. Email communication between attorney and client is privileged, assuming basic security precautions, because the attorney and client have a reasonable expectation of confidentiality in email, even though it passes through third-party infrastructure. Now, the AI privilege debate is tracking the same trajectory. The question is whether inputting client confidential information into an AI tool constitutes a disclosure to a third party that breaks privilege. And the answer, like the email answer, is going to be fact-specific and product-specific rather than categorical. Free consumer AI tools with terms reserving the right to access conversations are almost certainly a problematic disclosure, consistent with Heppner's logic as applied to attorney use. even though, again, that case did not actually decide that. Paid enterprise AI tools with a data processing agreement, explicit contractual confidentiality provisions, and an opt-out of model training are materially better and different and likely sufficient in the developing professional consensus, though no court has definitively ruled on this in the attorney use context. Now, individual paid subscription tiers like the Claude Pro subscription with the training turned off are better than the free tier, but they're not equivalent to an enterprise agreement with a data processing addendum. Training being turned off addresses one concern, that your inputs could be used to train the model and thus become more broadly accessible, but it does not address whether Anthropic employees or systems can access conversations, what happens in response to legal process directed to Anthropic, or whether a court would treat the paid individual tier as creating a sufficient expectation of confidentiality for privilege purposes. Now, because I'm a total nerd about this and curious, I actually had a conversation with Claude itself about the Pro subscription in the context of my practice. I'm a solo, so buying 5 seats for a team version of Claude, gives me a little pause. I don't want to pay for stuff I'm not using, but it may be worth it because Claude does not offer a single seat enterprise version of Claude. So I was using the Pro subscription and asked Claude about it. Claude's response was telling. Its conclusion, which I found quite useful, was essentially training being turned off helps, but does not change the recommendation dramatically, and the placeholder approach for client identifying information remains the cleanest solution. Claude Pro itself said not to trust it, not to break privilege. Okay, so I will link to that conversation in the show notes because I think it's worth reading as an example of how to think through this issue using the very tool you're evaluating. I mean, if it tells you not to trust it, I would go with that warning. ABA Formal Opinion 512, issued in July 2024, is the foundational guidance on attorney AI use. Now, it doesn't categorically prohibit AI use. What it requires is that before inputting client confidential information into any AI tool, an attorney must, number one, understand how the AI provider uses, stores, and potentially trains on submitted data. Number two, determine whether the provider's terms adequately protect confidentiality under Rule 1.6. Number three, take steps to avoid inadvertent disclosure, which may include using placeholders for client identifying information, using only enterprise tier tools with data processing agreements, or limiting what client-specific information is ever entered. Opinion 512 also notes that competence under Rule 1.1 requires attorneys to understand the technology well enough to assess these risks. You cannot simply assume an AI tool is safe for client-adjacent work. You have to actually evaluate the product's data handling. Yeah, okay, I mean, doing that extra amount of work is not fun, and it's hard to understand, but we can't just use it willy-nilly. Texas Ethics Opinion 705, issued in February 2025, goes a step further and emphasizes that attorneys must review all AI work product and understand the technology well enough to mitigate the specific risks of the tools they use. Blindly relying on AI output without independent verification of both the legal conclusions and the factual premises is an ethics problem under competence rules. Here's my practical recommendation for Illinois attorneys specifically, because I am an Illinois attorney. Call the ARDC ethics hotline before you rely on any paid AI subscription for work involving client identifying information. The hotline exists precisely for questions like this. The staff is genuinely helpful, and the call maybe takes 30 minutes and creates a record that you sought guidance. Illinois Rule 1.6 requires reasonable measures to prevent unauthorized disclosure. Reasonable measures in 2026 include, at a minimum, actually reading the terms of the tools you use and making an informed judgment rather than a default assumption. For the actual work we do here, I use AI as a drafting and research assistant routinely, and I recommend you do too. The efficiency gains are real, and ABA Tech Show 2026 drove home the point that lawyers who don't use AI to increase efficiency are going to be left behind, much the same way lawyers who never adapted to email were. But I use placeholders for client identifying information. I use it as a starting point that I verify and substantially revise, and I'm thoughtful about what goes in. The tool is not the problem. Careless use of the tool is the problem. I want to shift now to a topic that is getting far less attention than Heppner in the current conversation, but may represent a more immediate and more widespread ethics risk for practicing attorneys: AI meeting note takers. Tools like Otter AI, Firefly's AI, and Zoom's AI companion are increasingly standard in law firm environments. They transcribe meetings automatically, generate summaries, extract action items, and create searchable records. For administrative and business development purposes, they are genuinely useful. For client meetings and strategy discussions, they are a minefield. There's a privilege and confidentiality problem. The analysis I'm doing runs parallel to the Heppner analysis, but with an important difference. The attorney is the one introducing the tool, not the client, although, yes, sometimes the clients do introduce it. An AI note taker that is recording and transcribing a privileged attorney-client meeting is not a neutral observer. It's a third-party service that receives the communication, stores it on its own servers, and generates derivative documents, the transcript and summary, that exist outside your firm's controlled environment. The same third-party disclosure concern that applied to the client in Heppner applies here, but now you're the one potentially creating the disclosure. Courts have held that communications in the presence of third parties who are not agents of the attorney may not be privileged. The question of whether an AI note-taking service qualifies as an agent of the attorney for privilege purposes is unsettled, and the terms of most consumer-level note-taking tools do not support that characterization. The New York City Bar's Professional Ethics Committee addressed this in Formal Opinion 2025-6, issued in December 2025. The opinion is careful and worth reading in full, but the core guidance is clear. Lawyers must obtain client consent before recording any client meeting, regardless of whether the jurisdiction technically requires only one-party consent under its wiretap statute. The duty of loyalty and the client's reasonable expectation of confidentiality require disclosure and consent even where it's not legally mandated. The opinion also emphasizes that attorneys must understand where the data is stored, how long it's retained, and whether it's used for model training, and whether they have a right to delete it. These are the same ABA Opinion 512 inquiries applied to a specific tool category. Let's look at the artifacts problem, and this is the one most people are missing. The live recording of the meeting is an obvious concern. But what the bigger practical risk is what I call the artifacts: the transcript, the summary, the extracted action items. These exist as documents after the meeting ends. They're usually stored somewhere, often on the note-taking service's servers. They may be shared via links that don't require authentication. They may be retained indefinitely, and if they become the subject of a subpoena or discovery request, they are producible in a way that your own unrecorded mental notes are not. Think about what a complete AI-generated transcript of a privileged strategy discussion looks like as a discovery document. Every theory you explored, every weakness you acknowledged, every client instruction you received, all of it, formatted into clean, searchable text stored on a third-party server. Scary, right? The default answer for any meeting where attorney-client privilege or attorney work product is at stake is AI note takers off, full stop. You can turn them on for administrative meetings, business development calls, and anything that doesn't involve client matters. But for client meetings, strategy discussions, and any communication you would normally treat as privileged or work product, the AI note taker should not be running. Now, of course, there are exceptions. For example, Plod, which many lawyers are using, has enterprise-level security, encrypted file transfer and storage, and is even HIPAA compliant. It looks like its products and services with this kind of security may be acceptable as not breaking privilege, but it's safest not to use any of them without checking with your state bar ethics board for guidance. Let's look at an Illinois-specific wrinkle. Illinois is a two-party consent state under its eavesdropping statute. Recording a conversation without the consent of all parties is not just an ethics issue, it can be a criminal one. And Illinois has also enacted the Biometric Information Privacy Act, which covers voice prints derived from audio recordings. A class action was filed in December 2025 against Otter AI, alleging BIPA violations based on the creation of voice prints through AI transcription without proper disclosure or consent. This is not theoretical, this litigation is active. So before you use any transcription tool in your Illinois practice, you need to have obtained consent from all the participants, verified that the tool's data handling is compatible with their confidentiality obligations, and determined whether the tool's voice print creation triggers BIPA compliance requirements. If you're unsure about any of those, the tool should not be running in your meetings. Here's some practical guidance. Build AI tool policy into your engagement letters. State clearly that you may use AI tools for certain administrative and research purposes, describe the category of tools and their data handling, and obtain client consent, or explicitly exclude certain tools from client matters. If you're using Zoom for client meetings, verify your firm's Zoom settings. AI Companion is enabled by default in many paid Zoom configurations. Turning it off for specific meetings is not enough. It can be re-enabled accidentally or by participants who have their own settings. Your firm's Zoom admin settings should default AI features off for any meetings involving client matters with a deliberate opt-in for appropriate use cases. I want to spend some time on the hallucination and sanctions issue because the statistics have gotten genuinely alarming and because I think there's a framing problem in how this risk is being communicated to practitioners. The AI hallucination cases database, maintained by researcher Damien Charlton, tracked 863 reported incidents globally as of December 2025. That's not an occasional problem, that's a trend. The judicial responses have escalated accordingly. Let me walk through the current spectrum because it's broader than most practitioners realize. Mata v. Avianca, decided in the Southern District of New York in 2023, remains the landmark case. Attorneys submitted a brief containing AI fabricated case citations. The court opposed monetary sanctions and, in the description that has become something of a shorthand in the sanctions literature, required the attorneys to notify the client of the misconduct, the tell your mom what you did sanction. Versant Funding LLC versus Terrace, Southern District of Florida 2025, used language that should get every attorney's attention. The court characterized the use of non-existent AI citations as careless, negligent, and reckless. That's not a mild rebuke. Those are the building blocks of a malpractice finding and disciplinary procedures. The sanctions included reimbursement of opposing counsel's fees and mandatory AI-focused CLE. Johnson v. Dunn, Northern District of Alabama, 2025, and Bioplanet International versus Johansson, Southern District of Florida, 2025, escalated to attorney disqualification and what I am going to call the tell your whole family sanction, disclosure of the misconduct to the attorney's entire book of business, every client, not just the one in the case. And Nelson Henry versus Joseph Ianon and James Diacetis, Southern District of Florida, January 28, 2026, shows that the trend is continuing in 2026 with no signs of the judiciary becoming more tolerant. And why should they? They've told us for a few years now to knock this off. The framing problem I mentioned, these cases are often presented as warnings about AI tools as if the lesson is be careful with AI. And the actual lesson is more specific and more actionable. The lesson is that unverified AI output in a court filing violates your duty of candor under Rule 3.3, your competence obligation under Rule 1.1, and your duty of supervision under Rules 5.1 and 5.3 if the hallucinated filing was produced by a subordinate using AI. The tool is not the problem. The failure to verify is the problem. The practical requirement is a verification workflow, not abstention from AI. Specifically, every case citation generated by or with AI assistance must be verified against primary sources before it goes into any filing. Not checked to see if it looks plausible, actually pulled up in Westlaw, Lexis, or Fastcase, read and confirmed to say what you are representing it says. This isn't new. You've always been ethically required to cite check your work. The difference is that AI can generate plausible-looking fake citations at a volume and verisimilitude that was not previously possible, which makes the cite-checking step more important, not less. Several courts have now adopted local rules or standing orders requiring disclosure of generative AI use in court filings. The requirements vary, but the pattern is consistent. Disclose the tool used, certify that a human reviewed the output, and certify that all citations are accurate. The Northern District of Texas has such a rule. Judge Craig Schwall in Fulton County, Georgia, has a standing order requiring those elements. Pennsylvania state courts have adopted guidelines. If you're practicing in a federal district or state court where you do not know the current AI disclosure requirements, you need to find out before your next filing. This is a competence issue under Rule 1.1, and it is no longer an edge case. I want to briefly flag a development from March 2nd, 2026 that is directly relevant to any IP attorneys in the audience and any attorney advising clients who work in the creative or tech space. The Supreme Court denied cert in Thaler versus Perlmutter on March 2, 2026, leaving intact the D.C. Circuit's ruling that the Copyright Act requires copyrightable works to be authored by a human being. The Copyright Office's position that AI can't be an author, that purely AI-generated works are not eligible for copyright protection, and that human creative control is the determinative factor is now the settled law of the D.C. Circuit, with the Supreme Court having declined to review it. This doesn't end the litigation landscape around AI and copyright. Far from it. Training data cases are still working through the district courts. The precise contours of sufficient human control are still being developed through Copyright Office registration practice and the courts. But the foundational question, can AI be a legal author of a copyrightable work, is answered, at least until Congress acts or the court takes a future case. For IP attorneys advising clients, your clients who are creating works with AI assistance need to understand and document their human creative contribution. Clients who have already registered works with AI involvement and did not disclose it face potential registration challenges. And clients asking you about whether AI-generated work can be protected by copyright now have a clear answer at the circuit level, not without meaningful human authorship. There are important rules regarding AI and trademarks and AI and patents you should be aware of too. I covered the practical guidance for non-attorney creators in depth in last week's episode. The show notes link to that one for any clients you want to send in that direction. Let's pull this together with the practical takeaways. How do you survive AI ethics without losing your license? On Heppner, read the case, not the summaries. The holding is specific to client use of free consumer AI without attorney direction. It does not address attorney AI use, enterprise tools, or Kovel-directed client use. Counsel your clients about their own AI use and what it means for privilege. Their habit of running legal problems through ChatGPT or Claude on their own initiative before talking to you is now documented as a privilege risk. On attorney AI use, ABA Opinion 512 is your framework. Understand your tool's data handling. Use enterprise tier tools with data processing agreements for anything involving client confidential information. Use placeholders for client identifying details when working with non-enterprise tools. Call your state bar ethics hotline before you rely on a paid individual subscription for client-adjacent work if you have not already evaluated the product's terms carefully. On AI meeting note takers, default off for any meeting involving client matters or privileged communications unless you have received guidance from your state bar ethics line about the particular tool and plan being secure enough not to break privilege. Build AI tool disclosure and consent into your engagement letters. Know your jurisdiction's wiretap and biometric data consent requirements before any recording tool runs in your meetings. Understand that the artifacts, the transcripts, and summaries are the highest risk documents because they exist and are stored after the meeting ends. The advice your parents gave you about how just because your friends are doing something doesn't mean it's okay holds true here too. Just because your colleagues trust an AI tool doesn't mean you don't have responsibility to see for yourself whether it's trustworthy. On hallucinations and sanctions, the cite check step is mandatory. Every AI-generated citation must be verified against primary sources before it goes in any filing. Know your court's AI disclosure requirements. Supervise junior attorneys' AI use under Rules 5.1 and 5.3. On copyright, the D.C. Circuit's ruling in Thaler versus Perlmutter is that AI cannot be a legal author. It's now settled at the circuit level. Human authorship and human creative control are the legal standard. Document your client's creative processes, and remember there are important AI-related developments in trademark and patent law too, all covered in last week's episode. This is a rapidly evolving area. More bar opinions are coming, more cases are being decided. The practical guidance I have given you today reflects the state of the law as of early April 2026, and some of it will be refined by the time you hear this. Stay current. The ARDC Ethics Hotline and your state bar's ethics resources are your friends when it comes to AI. Avoid the legal horrors and keep rocking your IP. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode may contain attorney advertising material. The law firm address and other contact information is in the show notes and bio and available at kingpatentlaw.com.